This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court handed down 66 opinions on its regular docket in 2025, with significant decisions concerning religion, free speech, reverse discrimination, LGBTQ rights, gun regulation, parental rights, nationwide injunctions, and agency authority. 6 cases were decided by a court split ideologically 6-3, with the conservative justices in the majority and the liberal justices in dissent. Those were cases over hot-button social issues, like a ban on gender-affirming care for minors and religious accommodations in education. Joining me to analyze the decisions is constitutional law expert David Super, a professor at Georgetown Law. David, let's start with the case over religious charter schools that could have lifted the long-standing constitutional limits on government support for religion. And you can see the divide between the conservative and liberal justices in many of the cases dealing with religion.
And you say, oh, we're a religious school. It's like, oh, no, can't do that. That's too much. That's scary. We're not going to do that. And our cases have made very clear, and I think those are some of the most important cases we've had, of saying you can't treat religious people and religious institutions and religious speech as second class in the United States.
Because the essence of the Establishment Clause was, we're not going to pay religious leaders to teach their religion. That is and has always been the essence. And here we're paying Catholic leaders, Catholic teachers.
This was an unusual loss for religious plaintiffs at the court, but there were unusual circumstances. So tell us what happened.
Ultimately, nothing happened. There was an effort to create a religious charter school in Oklahoma. The Oklahoma Supreme Court, reading the Supreme Court's precedents on this, felt that that was excessive entanglement of church and state, that it was violating the Establishment Clause by using public resources to promote religion. It gets to the Supreme Court, and the court splits 4-4, which means that the Oklahoma Supreme Court decision is affirmed and the charter school is shut down. However, the reason the court had only 8 justices participating is because Justice Barrett recused herself, presumably because she's a former faculty member at Notre Dame, and a Notre Dame clinic was involved in much of this work. Apparently, some of her friends were. If a similar case returned to the court where all 9 justices were able to participate, based on her past writings, I anticipate Justice Barrett would vote in favor of the charter school, and they would win the war even though they lost this battle.
You anticipated my question because the supporters of charter schools here say the fight isn't over, so they're likely to bring another case to the court.
Oh, yes. The efforts to expand state subsidies of religion are quite well funded and quite energetic, and in many respects it was a strategic blunder to bring it from a state where one of the justices had connections. But there are plenty of other states that they can do this with, and the longer she's on the court, the fewer of these pre-court connections will entangle her.
Now let's turn to Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission. And this is about tax-exempt religious organizations?
Yes, this is kind of an odd case where Wisconsin had an exception from required contributions for certain kinds of religious organizations, but concluded that Catholic Charities didn't qualify because they provided services of a secular kind. And the Supreme Court looked at this and said, we do not want states to be making fine-tuned decisions about how religious organizations carry things out, distinguishing between those with a lot of proselytizing, a little proselytizing, and no proselytizing. This is too much intrusion of the state into religion. This has all sorts of potential for favoring one religious group over another. There are some religions that are absolutely opposed to proselytizing. There's some where it's the central act of religious devotion, and there's a bunch in between, and the court does not want distinctions drawn on that basis.
I was surprised that it was a unanimous decision. I mean, do you find that surprising?
I really didn't. I understand and respect the intentions of what Wisconsin was trying to do, but it was so complicated and so intrusive, and the lines they were drawing were so subjective that I think whether you are generally sympathetic with supporting religious groups or supportive of a strong line between church and state, that this is not a road you'd want to go down.
The next case, Mahmoud versus Taylor, involves religious rights, parental rights, and LGBTQ rights. Religious parents sued a school district that wanted to incorporate LGBTQ-friendly books in its curriculum. And the divide on the court was apparent when Justices Samuel Alito and Sonia Sotomayor disagreed over the storyline of one of the books, Uncle Bobby's Wedding.
Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this. Everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute. The reservation is about...
Can I finish, please? It has a clear moral message.
Is looking at the pictures, is there any affidavit from any parent that merely looking at people getting married, holding hands, none of them are even kissing in any of these books. The most they're doing is holding hands. That mere exposure to that is coercion.
This decision, which bolstered religious rights, came out 6-3 down ideological lines.
This was a case in which a school board added some LGBTQ plus friendly books to its curriculum. And initially, it provided notice to parents of when these books would be studied and allowed the parents to pull their kids out of those classes. But after a while, they concluded that this was defeating the purpose of broadening the portrayal of family life in their courses, so they no longer allowed opt-out. So the case came to the Supreme Court as to whether it denied the parents free exercise of religion to not be able to pull their children out of classes that were presenting LGBTQ plus people in a positive light. And the court ultimately concluded that the parents' rights required the school district to make an opt-out available. Justice Thomas then said, you'd better not try to get around this decision by integrating these materials broadly into your curriculum, because we'll shut that down too.
And the case is concerning, I think, on several levels. There was no evidence that the children would be harmed or influenced by the books, and the school district was just trying to expose the children to a more inclusive worldview. This is another in a line of cases where LGBTQ rights lose. And I'm wondering when or if the conservative justices will start protecting those rights.
Well, the court has certainly stepped way, way back from where it was when it recognized same-sex marriage in Obergefell, and even back from where it was when it recognized employment discrimination against LGBTQ people as a violation of Title VII in the Bostock case. I take this case, as you do, as being primarily about the court's disdain for LGBTQ rights rather than about parental rights. There are plenty of states around the country that are putting a strong skew in their curriculum, prohibiting teaching things about the history of African Americans, about certain episodes in the country's history, presenting the Civil War in a remarkably skewed and ahistorical event. And I would be very surprised to see the Supreme Court willing to give opt-out or similar rights to parents from those curricula. I think, unfortunately, this is part of the court's retrenchment on gay rights.
Yeah, and on the emergency docket, they allowed the Trump administration to kick transgender troops out of the military and allow this new policy requiring passports to reflect the sex on the holder's birth certificate. So they do appear to be going in that direction, which brings us to U.S. versus Skermetti. Again, a 6-3 decision on Tennessee's ban on gender-affirming care for minors.
This is a case that should have been very difficult for the court because the court had already in Bostock said that discrimination against people because they are gay or because they're transgender is a violation of the statutory ban on discrimination on the basis of sex. Some were afraid the court would overturn Bostock. They didn't, although some justices made clear they would love to. The majority didn't overturn Bostock, but it turned it into a sort of wordplay game where there's not perhaps that much vitality left in Bostock. They said, well, this isn't discriminating on the basis of sex because a child designated at birth as male who wants these treatments will be denied them on the basis of this policy, and a child designated at birth as female who wants these treatments will be denied them because they don't need these treatments. They're already female. And if that's true, then you can play a word game with just about anything. So the court here is at a very minimum sterilizing Bostock, limiting it to its specific holding. But more generally, it seems to be willing to engage in some quite dishonest wordplay to avoid the implications of civil rights laws. We've certainly seen that in other civil rights laws, but it's disturbing to see it quite this active.
We'll see if they follow suit in the decision over Colorado's ban on conversion therapy coming up next year. Let's turn now to a case about reverse discrimination, Ames versus Ohio Department of Youth Services.
Well, this was a straight white woman who believed that she was being discriminated against in various employment decisions, promotion and demotion decisions at her job, and sued for employment discrimination. The Sixth Circuit, which covers Ohio, had a doctrine that said if you are suing for discrimination as a member of the majority group, you need to present some evidence that makes it likely for people to think that you were discriminated against. The idea that the Sixth Circuit has is someone who has the deck stacked in their favor needs to show why this is not the case in a particular setting. And she didn't do that, so she lost. And the Supreme Court reversed and said that the standard for discrimination cases brought by members of majority groups or minority groups are the same. And the court, I think, concluded that the standard that the Sixth Circuit had established was just impossible to sustain in light of their holdings in particularly the school affirmative action cases. So the court ended up being unanimous on this, and Justice Jackson wrote for the majority.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Georgetown law professor David Super. We'll look at Supreme Court decisions involving nationwide injunctions, free speech, and gun regulations. I'm June Grasso, and you're listening to Bloomberg. One of the most high-profile Supreme Court decisions of the year was the case limiting the power of judges to block government policies across the country, so-called nationwide injunctions. The court's conservatives and liberals split 6-3 in Trump versus Casa, a decision that President Trump praised.
Thanks to this decision, we can now promptly file to proceed with numerous policies that have been wrongly enjoined on a nationwide basis. And some of the cases we're talking about would be ending birthright citizenship.
But that didn't happen, at least not yet. I've been talking to Georgetown law professor David Super about the court's opinions in 2025. David, this case was about Trump's attempt to restrict birthright citizenship, but the decision was about nationwide injunctions and limiting the power of judges to issue them.
This is a case that got a lot of attention that I frankly don't think it deserved. The practice of some lower courts has been to enjoin the administration nationwide from carrying out a policy that the lower courts find is illegal or unconstitutional. The Supreme Court says you can't just order a nationwide change on your own. But if the case is filed as a class action, then you can order nationwide relief for a nationwide class. So it's going to require plaintiffs to file cases as class actions. That's a little extra work. In a few situations, that may not be easy to do, but most of the time you can. And it's opened several other doors for getting national relief against what agencies are doing. So it's a fairly technical case. It's a case in which the court claims to be reaffirming its originalist credentials. I think they also get the history wrong, but at least that's what they say they're doing. And it won't change the outcome in the cases about birthright citizenship. The lower courts were all able to reinstate their orders after plaintiffs filed a class action. So I don't think this is going to affect very many cases. It certainly is not going to affect birthright citizenship, which is back up to the Supreme Court on the merits now.
Let's turn to another case that divided the justices down ideological lines 6-3. Free Speech Coalition versus Paxton was a challenge to a Texas law that required visitors to porn websites to verify their age. And several of the justices expressed concerns about how easily teenagers can get access to porn today. Here's Justice Amy Coney Barrett.
I mean, kids can get online porn through gaming systems, tablets, phones, computers. Let me just say that content filtering for all those different devices, I can say from personal experience, is difficult to keep up with.
Tell us about this free speech challenge.
This deals with a question of priorities. Porn can be denied to minors. There's lots of psychological evidence it can be quite destructive of minors. The court has upheld shielding minors from it. But there are many things that are not acceptable for minors that are protected for adults by the First Amendment. And the question here is, which of those do you prioritize, protecting the minors or providing access for the adults? And Texas enacted this law requiring age verification by porn sites that the Supreme Court majority upheld as consistent with protecting minors. The dissent said it's got too much of an impact on adults and is therefore a denial of free speech.
Half the states now have these age verification laws. Do you think that a few of the cases this year can be looked at in terms of reaffirming states' rights?
You could say that, but I think the court is not a serious federalist court. They are strongly in favor of states doing what they like the states to do, and they are absolutely appalled when the states do something they don't like. So it's very hard to see a meaningful states' rights theme in what the court is doing. You certainly could 10, 15 years ago, but I don't think you can now.
Now let's look at a case that was applauded by gun safety advocates. Bondi versus Vanderstock. It was a 7-2 decision about ghost gun kits with Clarence Thomas and Samuel Alito in dissent. No surprise there. It seemed like a pretty easy case.
It really was a pretty easy case. It was a gun case, but not a Second Amendment case, or not meaningfully a Second Amendment case. The Gun Control Act that was passed right after Dr. King and R.F. Kennedy Sr. were assassinated gave the Bureau of Tobacco and Firearms the authority to regulate certain weapons. And the advent of ghost guns, of gun kits that could be rapidly assembled without serial numbers so the guns would be untraceable, prompted the government to put out regulations restricting them in some of the same ways that other guns are restricted. And the gun lobby and the gun manufacturers said, oh, you have no authority to do this under the statute, so as a matter of administrative law, you must stop. Not a Second Amendment case, just an argument the agency exceeded its lawful authority. And the Supreme Court majority said, no, this is actually squarely within the act. All we require is that there be a weapon and that it be capable of ejecting a projectile with some modification. Starter pistols have been regulated since time immemorial. And this is really no different than that. This is a gun minus a little bit of work, which is certainly something they can regulate.
In June, the court declined to consider a new expansion of constitutional gun rights, turning away challenges to a Maryland ban on assault weapons and a Rhode Island prohibition on high-capacity magazines. Can we read anything into that declination, plus what we saw in the Ghost Guns case?
The Ghost Guns case is basically an administrative law case. The claim that was brought by the gun industry was laughable, and I think they were hoping that because they're the gun industry and they're supposed to win everything, that they could win even with a case that no one else could. And the Supreme Court, I think, maybe was a bit insulted at such a brazen presentation of an awful case. Denials of cert are very hard to read. There's often a lot of strategy going into them. The Supreme Court's in a bind here, though, because it's talking more and more and more about originalism, and yet its interpretation of the Second Amendment is completely anti-originalist. So every time it takes a Second Amendment case, it has to choose between embarrassing its originalist ideals and philosophy and offending the gun lobby, and not taking cases is a way of avoiding putting itself to that kind of a decision. The simplest approach would be to reverse Bronin and Heller and go back to an originalist view of the Second Amendment, but apparently that's a bridge too far.
Let's turn to a unanimous decision next, where the court sided with the FDA's rejection of applications for vaping products formulated to taste like fruit or candy and likely to be used by kids, as Justice Elena Kagan explained.
Flavors, you give people blueberry vapes. The difficulty with that, and FDA, I think, has tried to document this, is that blueberry vapes are very appealing to 16-year-olds, not to 40-year-olds.
We were talking about the gun industry earlier, and now we come to the tobacco industry. They're equal in consumer abuse, and the tobacco industry is selling vaping products nominally to get existing smokers off of cigarettes, but in fact to attract a whole new set of young people to endanger their health. And the FDA rejected marketing approval for a number of these items, and the tobacco companies said, well, the grounds cited in the denial don't quite match up with some of the things that the FDA said earlier, so that's a violation of administrative law. And the Supreme Court gave us a long-winded version of, oh, come on. And they said that it was very clear that the FDA had acted in just the way that it had said before, that there's no reason the cigarette companies should have thought that it was going to come out any differently. In other cases, when the FDA provided a somewhat more thorough review, it came to the same result, and there's simply no reason to think that sending it back to the FDA would get any different result. And it cited the Administrative Procedure Act, which specifically tells courts not to interfere in cases where the result clearly was correct.
David, does this case say anything more about the court affirming the FDA's authority, or is it confined to its facts?
This case is, I think, more interesting in general administrative law terms than it is in tobacco or FDA terms. There's been a controversy going back at least to the Reagan administration, arguably earlier, about what agencies have to do when they change their positions. And we've got a lot of that going on right now because Trump appointees are pretty different than Biden appointees. And the court here said that agencies don't have to go through a lot of process when the change in their position is small and predictable. So if the Trump officials want to make minor changes around the edges as to what the Biden people were doing, that there won't be a need for something fairly elaborate. I am not aware of a lot of Trump administration officials that are making only minor changes, but I'm sure there's some out there somewhere. And so the court said that if the change is minor, you don't need an intricate procedure. And that will, I think, be useful guidance as agencies refine their policies of the future.
Finally, Medina versus Planned Parenthood. It was about individual Medicaid patients' ability to sue. Is it having an effect?
There's a provision in the Medicaid statute assuring patients, beneficiaries, of the right to choose their providers. Most of us care a lot about who our healthcare provider is, and this was understood in Medicaid, which was trying to provide health insurances similar to other health insurance as they feasibly could. And the question is, when a state violates that, can beneficiaries sue? And the Supreme Court, in a number of cases over the years, has cut back on when you can sue when the law is violated. It's a strange concept for non-lawyers that someone has violated the law in a way that hurts you and you can't sue. But that's what the Supreme Court has said. And in this case, state are trying to throw Planned Parenthood out of Medicaid, and presumably because they think exposure to Planned Parenthood will cause some people to think about abortions or about birth control. And the Supreme Court held that people denied choice of provider by these laws do not have the right to go to court.
It's striking to me that in cases involving culture war issues, we almost always see the 6-3 ideological split, with the court's conservative supermajority prevailing, of course.
Well, I mean, almost all the cases you asked me about are cases with important social concerns. One of these days we'll do a riveting podcast on securities law cases. So these are all significant cases. The unanimous ones, I think, are mostly ones where a lower court just got very lost and did something that was so unreasonable that either the liberal justices or the conservative justices were not willing to stand behind it. The one example that would seem to be an exception here is the Oklahoma case that we talked about, where there was a conservative justice who voted with the liberal justice to get to the 4-4 impasse. So it's not a completely ideological court. There were 4 conservatives that voted with the liberal justice on the ghost guns case, recognizing that the arguments there were quite foolish. But yes, the court is quite polarized on culture war cases and on executive power cases. So we don't have the kind of national mediating institution in the court that we did in earlier years when it all came down to Justice O'Connor or Justice Kennedy, or back in the 1970s when you had 2 very liberal justices, 2 very conservative justices, and 5 legitimately up for grabs swing justices. We don't have that kind of court anymore.
No one can dispute that. Thanks so much, David, for helping us understand the implications of the decisions this year. That's Georgetown law professor David Super. Coming up next, Luigi Mangione is trying to get crucial prosecution evidence thrown out. I'm June Grasso, and you're listening to Bloomberg.
Flare 911, what is the address of your emergency?
It's not really an emergency. I'm a manager at Plank Road McDonald's out here on the Boulevard.
Okay.
And I have a customer here that some other customers were suspicious of, that he looked like the CEO shooter from New York.
Okay.
That was a 911 call that led police to the McDonald's in Altoona, Pennsylvania, where Luigi Mangione was eating breakfast last December. Mangione is trying to get a judge to exclude crucial evidence from an eventual trial on charges that he murdered United Health Group executive Brian Thompson last year in New York. At an evidentiary hearing that spanned 7 days of testimony from 17 witnesses, prosecutors played body camera footage of his arrest at the McDonald's, starting with an officer approaching Mangione and asking for ID.
How you doing? Good. Put your mask down real quick for me? Yeah, sure. Appreciate it. I do. Okay. What's your name?
Mark.
What is it?
Mark.
Mark?
Yes, sir.
Mark what?
Rosario.
Rosario? Someone called. They thought you were suspicious.
Oh, I'm sorry.
Judge Arviondi? Yes, sir. Thanks.
It ended with Mangione in handcuffs, but not before a police officer rifled through his backpack, finding a loaded gun magazine wrapped in a pair of underwear. Police searched the backpack more thoroughly at the police station and found evidence including a 9mm handgun that prosecutors say matches the gun used to kill Thompson, a silencer, a passport, and a notebook they've described as a manifesto. But police didn't get a warrant until after both searches of the backpack. And the defense says that violates Mangione's constitutional rights against illegal search and seizure, and all that evidence should be thrown out. Mangione has pleaded not guilty to 9 state counts, including second-degree murder and various weapons charges. He's also pleaded not guilty to 4 federal charges in a separate case. My guest is former federal prosecutor Robert Mintz, a partner at McCarter & English. Bob, there are suppression hearings all the time in criminal cases, although probably not lasting as long with as many as 17 witnesses.
That's true. And what you have when you're a defense lawyer heading into a criminal trial are really very few weapons to try to knock out the government's case before you go to trial. Once there is an indictment, you really have the opportunity only to try to suppress certain evidence. In other words, argue to the court that the evidence obtained by prosecutors and that prosecutors intend to rely on to gain a conviction at trial were somehow obtained illegally in violation of your client's constitutional rights and therefore should not be used at the trial. So what we're seeing here is something that defense lawyers try to do all the time. But as you say, this has turned into a much more protracted hearing going approximately 3 weeks. Still, at the end of the day, any suppression hearing in any criminal case is going to be an uphill battle for the defense, because what the defense is really trying to do here is knock out critical evidence that could be used against their client and would have a very significant impact on the likely outcome of the trial. So judges are, generally speaking, reluctant to suppress key evidence before a trial. One interesting aspect of this lengthy suppression hearing is that even if the defense loses its motion to suppress its evidence, as it likely will, there's still a huge benefit for the defense because they've now heard testimony from a large number of police officers who will testify at the trial. And what it gives them is a preview of the state's case, and it also gives them a script by which they can cross-examine those witnesses later at trial. So even if they lose this case, there's still a benefit to the defense, and they can essentially lose the battle but potentially win the war down the road by using the testimony at the suppression hearing against those witnesses at trial.
Now, the defense is arguing that the police should have gotten a warrant before searching the backpack.
Essentially, what the defense has argued with regard to the backpack is that the search was illegal, and therefore all of the evidence obtained from that search, the key evidence in that backpack that is absolutely critical to the state being able to prove its case at trial, since it includes, among other things, the gun that the state alleged was used in the shooting. They argue that the search was illegal because it was not done pursuant to a warrant. And what the defense has said is that a warrant could have been obtained and, in fact, was not until much later. During the hearing, there was evidence played from the body cam footage of the police officers where you see officers debating among themselves whether they should get a warrant to search the backpack at the McDonald's or whether they should wait and bring the backpack back to the police station and then get the warrant. Ultimately, they decide not to get the warrant at the McDonald's, to go back to the police station, and to get the warrant only after the backpack has been searched back at the police station.
Prosecutors argue the search was legal because it was an exception to the warrant requirement. And the police officers testified that they were looking in the backpack to see if there were any explosives or other dangerous items. But on cross-examination, the defense attorney asked the officer why she continued to search through the bag without a warrant even after she determined that there were no explosives, and why police never cleared the restaurant of customers and employees if they thought there was an explosive.
What the prosecution has argued here is that the search was legal because it was done pursuant to an exception, and that is called a search incident to arrest. So what prosecutors have said was at the time that the police officers approached Mr. Mangione at that McDonald's, they asked for his identification. He gave them a false identification, and he identified himself as Mark Rosario, giving him a false name. Police officers ran that information. They quickly learned that the identification was false, and the prosecution now argues that the search was done incident to the arrest, the crime being giving false information and a false ID to the Altoona police officers. And so they're saying that the search is legal because it's incident to arrest, although typically a search incident to arrest is done for purposes of securing the safety of the officers and of the surrounding people. And that's why the defense focused a lot on trying to demonstrate that the search of the backpack went beyond merely determining that there was nothing in there that could be a threat to the officers or a threat to anybody else in the McDonald's, that they went beyond what should have been permitted in a search incident to arrest to look for evidence rather than merely determining that there is nothing in the backpack that would pose a threat to the officers or to the public.
So minutes after the police approached Mangione in the McDonald's, he told an officer that he didn't want to talk. That's according to video and testimony, but police continued asking him questions and he continued answering. And nearly 20 minutes passed before they read him the Miranda warnings. And so his lawyer is arguing that any of his statements should be excluded.
So the body camera footage does show that an officer read Mr. Mangione's Miranda rights, but it wasn't until 20 minutes after they first started asking questions, and Mr. Mangione had said that he did not want to answer their questions. He did not ask for an attorney. Otherwise, officers would have had to have stopped asking those questions. But the question raised by the defense lawyers was, should he have been apprised of his Miranda rights sooner? Miranda rights are the all-important advisement of a defendant's right to remain silent and the right to have an attorney before any questioning continues. And the defense has argued that not only the comments made by Mr. Mangione on December 9th at the McDonald's should be suppressed, but also his comments through his extradition to New York 10 days later should also be set aside.
Bob, what will the judge consider as far as the delay in giving the Miranda warnings?
In terms of analyzing whether Mr. Mangione should have been given his Miranda rights sooner than 20 minutes after police officers first started questioning him, the judge is going to look at the critical question of whether or not he was in custody and whether he was actually being interrogated by law enforcement. That's the standard. When an individual is considered in custody and being interrogated by law enforcement, that is the moment that triggers the requirement that they be given the Miranda warnings. So the question here is, when they were standing in that McDonald's, can the defense convince the court that Mr. Mangione was in custody and, in fact, was being interrogated by police officers at the time? The prosecution has argued that he was not in custody, that he was not prevented from leaving the McDonald's, and that he was not formally being interrogated until about 20 minutes into the questioning, and that is the point at which he was given his Miranda rights.
And Mangione's defense attorney argued that he was effectively in custody because officers had formed a human wall around him at the McDonald's. You mentioned before that it's not likely that the judge will kick out this evidence. Will you explain in a little more detail why you feel that way?
The issues that were raised during the suppression hearing are enormous from the standpoint of the prosecution. What's at stake here is the evidence that really goes to the heart of the prosecutor's case. Were the judge to decide to suppress the search, that would bar prosecutors from using the 9mm handgun allegedly found in the backpack that matches the firearm used in the killing. It would bar prosecutors from presenting at trial writings in the notebook that, according to prosecutors, laid out Mangione's disdain for health insurers and ideas about killing a CEO at an investor conference. And it would also bar them from using evidence that ties the false name that he gave to police officers at the McDonald's with the name that was used by an individual checking into the New York hostel days before the shooting. So the stakes are enormously high, and generally speaking, judges will give the benefit of the doubt to police officers and to law enforcement if there's a credibility question between the defendant and law enforcement. I think what will be critical to the analysis here regarding the search is that there was a crime committed by giving the false information, and the question then is raised as to whether the search incident to that arrest was appropriate or not.
In this day and age where most people can probably recite the Miranda warnings from watching them on TV or in the movies, why do police hesitate to give them?
Police officers argued that they were trying to keep him calm and trying to determine if, in fact, he was the person who law enforcement was looking for while they questioned him. It's still a big deal, even though, as you say, people can recite those warnings from watching Law & Order and many of the other television shows. That is something that still has to be given at the appropriate time, and the failure to do that can result in statements being suppressed and not being presented at trial. So it's a very big deal here, and the judge is going to have to look at the question of whether or not he was actually in custody. He was surrounded by police officers, but the prosecution will argue that at no time did he ask whether he could leave, did he make an attempt to leave, or did prosecutors tell him that he couldn't leave the McDonald's, and therefore he was not in custody at the time that they asked him these questions and was not being interrogated at the time that they asked him these questions, and therefore the decision to not Mirandize him for 20 minutes was appropriate and should not result in a suppression of those statements.
And we'll have to wait until May 18th to find out the judge's ruling. Thanks so much, Bob. That's Robert Mintz of McCarter in English. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.